Section 10. And be it further enacted that there shall be appointed an attorney for said territory, who shall continue in office for 4 years, unless sooner removed by the President, and who shall receive the same fees and salary as the Attorney of the United States for the present territory of Oregon. There shall also be a marshal for the territory appointed, who shall hold his office for 4 years, unless sooner removed by the President, and who shall execute all processes issuing from the said courts, when exercising their jurisdiction as circuit and district courts of the United States. He shall perform the duties, be subject to the same regulation and penalties, and be entitled to the same fees as the Marshal of the District Court of the United States for the present territory of Oregon, and shall, in addition, be paid $200 annually as a compensation for extra services. Section 11. And be it further enacted that the Governor, Secretary, Chief Justice, and Associate Justices, Attorney, and Marshal shall be nominated, and, by and with the advice and consent of the Senate, appointed by the President of the United States. The Governor and Secretary to be appointed as aforesaid shall, before they act as such, respectively, take an oath or affirmation before the district judge or some justice of the peace in the limits of said territory, duly authorized to administer oaths and affirmations by the laws now in force therein, or before the Chief Justice or some associate justice of the Supreme Court of the United States, to support the Constitution of the United States, and faithfully to discharge the duties of their respective offices, which said oaths, when so taken, shall be certified by the person by whom the same shall have been taken, and such certificate shall be received and recorded by the said Secretary among the executive proceedings, and the Chief Justice, and Associate Justices, and all other civil officers in said territory, before they act as such, shall take a like oath or affirmation before the said Governor or Secretary, or some judge or justice of the peace of the territory, who may be duly commissioned and qualified, which said oath or affirmation shall be certified and transmitted by the person taking the same to the Secretary, to be by him recorded as aforesaid, and afterwards the like oath or affirmation shall be taken, certified, and recorded in such manner and form as may be prescribed by law. The Governor shall receive an annual salary of $1,500 as Governor, and $1,000 as Superintendent of Indian Affairs. The Chief Justice and Associate Justices shall each receive an annual salary of $1,800. The Secretary shall receive an annual salary of $1,800. The said salaries shall be paid yearly, at the Treasury of the United States. The members of the Legislative Assembly shall be entitled to receive $3 each per day during their attendance at the sessions thereof, and $3 each for 20 miles travel, in going to and returning from the said sessions, estimated according to the nearest usually travel route. There shall be appropriated annually the sum of $1,000, to be expended by the Governor to defray the contingent expenses of the territory. There shall also be appropriated annually a sufficient sum to be expended by the Secretary of the Territory, and upon an estimate to be made by the Secretary of the Treasury of the United States, to defray the expenses of the Legislative Assembly, the printing of the laws, and other incidental expenses. And the Secretary of the Territory shall annually account to the Secretary of the Treasury of the United States for the manner in which the aforesaid sum shall have been expended. Section 12. And be it further enacted that the Legislative Assembly of the Territory of Utah shall hold its first session at such time and place in said territory as the Governor thereof shall appoint and direct, and at said first session, or as soon thereafter as they shall deem expedient, the Governor and Legislative Assembly shall proceed to locate and establish the seat of government for said territory at such place as they may deem eligible, which place, however, shall thereafter be subject to be changed by the said Governor and Legislative Assembly, and the sum of $20,000 out of any money in the Treasury not otherwise appropriated is hereby appropriated and granted to said territory of Utah, to be applied by the Governor and Legislative Assembly to the erection of suitable public buildings at the seat of government. Section 13. And be it further enacted that a delegate to the House of Representatives of the United States, to serve during each Congress, of the United States may be elected by the voters qualified to elect members of the Legislative Assembly who shall be entitled to the same rights and privileges as are exercised and enjoyed by the delegates from the several other territories of the United States to the said House of Representatives. The first election shall be held at such time and places, and be conducted in such manner as the governor shall appoint and direct, and at all subsequent elections, the times, places, and manner of holding the elections shall be prescribed by law. The person having the greatest number of votes shall be declared by the governor to be duly elected, and a certificate thereof shall be given accordingly, provided that said delegate shall receive no higher sum for mileage than is allowed by law to the delegate from Oregon. Section 14. And be it further enacted, that the sum, or $5,000 be, and the same is hereby, appropriated out of any moneys, in the Treasury not otherwise appropriated, to be expended by and under the direction of the said Governor of the Territory of Utah, in the purchase of a library, to be kept at the seat of government, for the use of the Governor, Legislative Assembly, Judges of the Supreme Court, Secretary, Marshal, and Attorney of said territory, and such other persons, and under such regulations as shall be prescribed by law. Section 15. And be it further enacted, that, when the lands in the said territory shall be surveyed under the direction of the government of the United States preparatory to bringing the same into market, sections numbered 16 and 36 in each township in said territory shall be, and the same are hereby, reserved for the purpose of being applied to schools in said territory, and in the states and territories hereafter to be erected out of the same. Section 16. And be it further enacted, that temporarily, and until otherwise provided by law, the governor of said territory may define the judicial districts of said territory, and assign the judges, who may be appointed for said territory, to the several districts, and also appoint the times and places for holding courts, in the several counties or subdivisions, in each of said judicial districts, by proclamation, to be issued by him, but the Legislative Assembly, at their first, or any subsequent session, may organize, alter, or modify such judicial districts, and assign the judges, and alter the times and places of holding the courts, as to them shall seem proper and convenient. Section 17. And be it further enacted, that the Constitution and laws of the United States are hereby extended over and declared to be in force in said territory of Utah, so far as the same, or any provision thereof, may be applicable. Approved, September 9, 1850, an act to amend, and supplementary to, the act entitled An Act Respecting Fugitives from Justice, and Persons Escaping from the Service of their Masters, approved February 12, 1793. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the persons who have been, or may hereafter be, appointed commissioners, in virtue of any act of Congress, by the circuit courts of the United States, and who, in consequence of such appointment, are authorized to exercise the powers that any justice of the peace, or other magistrate of any of the United States, may exercise in respect to offenders for any crime or offense against the United States, by arresting, imprisoning, or bailing the same under and by virtue of the 33rd section of the Act of the 24th of September 1789, entitled An Act to Establish the Judicial Courts of the United States, shall be, and are hereby, authorized and required to exercise and discharge all the powers and duties conferred by this Act. Section 2. And be it further enacted, that the Superior Court of each organized territory of the United States shall have the same power to appoint commissioners to take acknowledgments of bail and affidavits, and to take depositions of witnesses in civil causes, which is now possessed by the Circuit Court of the United States, and all commissioners who shall hereafter be appointed for such purposes by the Superior Court of any organized territory of the United States, shall possess all the powers, and exercise all the duties conferred by law upon the commissioners appointed by the circuit courts of the United States for similar purposes, and shall moreover exercise and discharge all the powers and duties conferred by this Act.